Hi all, greetings from Canberra. Today we're going to have a hypothetical session without the strutting. So no room strutting today unless we can fit that in from our small screens. So our panel today comprises Jason from Queensland, welcome, Tim from Victoria, John from New Zealand, who I understand is on his way and should be here shortly, Stephen from New South Wales, and Pino from Western Australia. So today what we're going to do is we're going to go through a nuanced cross-jurisdictional response by way of hypothetical to my three scenarios to do with the rogue strata manager. And off we go. A rogue is but a vagrant, a tramp by another name, a dishonest or worthless person, a scoundrel. To apply this descriptor in the context on which I embark, comes with the potential threat of law society proceedings, defamation and harassment. But bravely I will take on that challenge in the interests of the broader strata community and naturally on a hypothetical basis. So the rogue strata manager. Let me introduce you to Maria and scenario one. Maria is a strata manager and licensee in charge of Strata Management Matters, SMM, with a catchy byline, "Your investments are our passion. We know that the three most important things to anyone are cash flow, peace of mind, and return on investment." SMM has embarked on an aggressive growth strategy and touts itself as being one of the only strata managing companies to offer services Australia and New Zealand wide. Such drafting really gives some indication of where Maria is taking this company. Part of the SMM expansion strategy across markets is to target more vulnerable OCs who have had or are experiencing significant building and management issues and that are in the process of changing over strata managers, and that they have been enticed by SMM's low pricing and cross-jurisdictional leverage for operational issues and greater perceived resources and systems. SMM grows its base by responding to EOIs across jurisdictions and signs up a new OC, aptly named Diddled OC in the ACT. The OC does not get advice on the strata management contract and relies on the assurances made by SMM that it holds all relevant licenses to operate in the ACT. It does not appear that much due diligence has been conducted, and presumably SMM had got through the EOI process on price and national experience and strength. All appears well, and the OC is attempting to address some of its historical issues with SMM, leading the way, when some of the OC's contractors start complaining about unpaid bills. In following up with the inquiry with the strata manager, the Treasurer of the EC is assured that payments will be made soon. There are just some auditors conducting a review of the accounts currently held throughout Australia and New Zealand, and that matters will be business as usual on completion of the audit. The EC then receives notification that joint managers of the company have been appointed by New South Wales Fair Trading, but that SMM is not currently in voluntary admin, receivership or liquidation, and that the role of the managers is to undertake a reconciliation of the trust accounts while managing the ongoing business. The correspondence rightly raises concerns in relation to monies that may be unaccounted for and that some communities may need to raise special levies if there is such a deficiency, and alerting the EC to the possibility of making a compensation claim against the applicable statutory government fund. This, however, cannot commence until such time as the monies that may be deficient are sufficiently identified. It is noted that the managers intend to sell the SMM business and will continue to trade it until such sale occurs. The managers note that the business trades in every state and territory and in New Zealand, and that the process of completing the audit will accordingly take some time. So now I'm going to propose a few questions to each of the panel. So Jason, From the Queensland perspective, you've received a call from the Treasurer of an OC when they received the notice from the administrators, which refers to sections of the New South Wales legislation in relation to the appointment of administrators, and they ask you for guidance as to what it means for them in the context of Queensland law and what is the applicable compensation fund if they have a shortfall in their accounts.
Well, Susan, in Queensland, there is no regulation or licensing of strata managers. But as an aside, the Queensland government is in the process of reviewing our legislation and the appropriate model that would enable regulation of strata managers. It's definitely on the agenda. So absent a Queensland licensing regime accompanied by a compensation fund, I'd encourage the body corporate to look at the insurance policy that it holds, particularly whether it provides fidelity cover and the limits of that cover. And if it's available, that should provide the Queensland body corporate a bit of comfort. And if there are funds that are not accounted for, then an insurance claim could be made. But one of the credits to this college is the opportunity that it provides to learn from practitioners in other jurisdictions. And in the course of my preparation for this, I consulted with such a practitioner. Thank you, Susan. And it was very interesting when we were discussing the issue. We learned that it may very well be available to the Queensland body corporate that given this manager is licensed in New South Wales, they could explore whether they could actually make a claim under the New South Wales Compensation Fund pursuant to Section 173 of the Property Stock Agents Act for the failure to account. And that could be available because the manager's notice notified them all that they were conducting an audit of accounts throughout all of Australia. It wasn't just the licensee's accounts held within New South Wales. But if the Queensland body corporate were to assume that New South Wales Fair Trading had stepped in because of just their conduct in New South Wales, but it was worried about whether something similar could happen to its funds in Queensland, it could issue a notice under our regulation modules requiring the return of its records and all of its property, and it could get its own external audit undertaken.
Thank you, Jason. Appreciate that. Tim, you've noticed that some of your accounts have not been paid by SMM for work that you have completed for an OC in Victoria. In following up, same, the OC seeks your advice as to whether or not they should terminate the strata management contract in those circumstances. What process would you recommend the OC embarks on?
It's not unknown, of course, that doesn't apply to any Victorian managers in today's delegation, but carving those out, that's something that's not entirely unfamiliar. I suppose the first thing to countenance is whether you have a conflict, and that may be a legal conflict, it might be more of a relationship or commercial conflict, but in terms of, I suppose having checked that box, the next proposition is who is your client and who has been your client. But it seems to me that it's a clear agency relationship. We heard from Gary yesterday about fiduciaries and his characteristically excellent paper. But it seems that in terms of termination, there needs to be grounds. The statutory position is that an owners corporation here has unfettered right to terminate a manager. It doesn't need any grounds, but those run parallel. It doesn't extinguish common law contractual rights. So if the termination constitutes a repudiation on the OC's part by depriving the manager the right to manage for the term for the fee, there could be a substantial damages claim. The only probably two things arising out of that are these. One is whether the committee will have the power to make that decision and execute it on the OC's part. That's a very vexed question. The standard form SCA contract purports to withdraw that power from the committee. VCAT's overlooked that, but it is a power that can be withdrawn, but typically is not. And also the measure of damages, if there has been repudiation on the OC's part, there's an interesting case down here called Strata Plan, where the manager sought damages being the full value of the pro rata remaining tenure, and what the tribunal did was call for its tax returns to look at what its actual profit was in managing that building, and awarded less than $100 multiplier over a couple of years. So maybe you can repudiate these things all you like and you're not at risk of substantial damages claims.
Right, interesting. John, we've got you from New Zealand. That's fabulous. Can you hear me? You just need to unmute yourself, John.
Can you hear me now?
I can hear you now. That's fabulous. Thank you, John. So, John,
Okay.
a question for you from a New Zealand perspective. The Treasurer of the OC calls you, this is in relation to scenario 1, and seeks your urgent advice as to what to do on receipt of advice that there are anomalies in the trust accounts of SMM, which have been notified through the generic correspondence issued by the joint managers of New South Wales Fair Trading. The Treasurer asks you what, if any, statutory fund government compensation exists in your jurisdiction, and if so, how does it work?
Okay, well, in the New Zealand context, not New South Wales, we don't have any compensation available Treasury investigation. We also don't have under our legislation any penalty rate, which is quite surprising.
John, can you just speak a bit close to your microphone, please?
Okay, sorry, Tim.
That's better.
So I'm just saying that we don't have any offence provisions or prescribed penalties in New Zealand. The only regime that we have in our 2010 Act is the possibility of having the Ministry of Business Innovation Chief Executive launch an investigation. So from my perspective, a pragmatic suggestion would be to have the carry out its own independent investigation and use its own initiative from a pragmatic point of view. Equally, you could, if it was serious, initiate a private fraud investigation or involve the New Zealand Serious Fraud Squad to investigate any major Treasury breaches.
Thanks very much, John from New Zealand. Stephen, you're contacted by your ACT college buddy, who is the solicitor tasked with making the New South Wales claim for the ACT Owners Corporation when it becomes known that Diddle OC has had over 1 million in funds misappropriated. I understand many cheques were drawn directly from the trust account into the agent's pocket. Your college buddy seeks your guidance as to how long such claims could take in New South Wales and how successful they generally are, and what other avenues you may take.
Who would have thought New South Wales would be so far ahead of the pack? The starting point in this scenario is having good forensic evidence as to what has actually been, the value of what's been diddled. The Owners Corporation can't be its own witness. It needs forensic evidence demonstrating what the loss has been. The first port of call is going to be their insurer, because as Jason indicated a little earlier, it's highly likely that the Owners Corporation insurance portfolio will have a fidelity fund cover of some kind. All insurers like forensic evidence attached to claims. The second port of call after the insurer is obviously the Office of Fair Trading. The Property Stock and Agents Act creates a fund called the Property Services Compensation Fund. That compensation fund receives contributions from all licensees under the legislation to cover situations such as this. The Commissioner for Fair Trading is the person responsible. There is a limit to the claim that can be made. The Owners Corporation will want to go to its insurer first because it needs to establish to the Commissioner that it's mitigating its loss as best it's able. After that claim has been made, the Commissioner can then negotiate with the insurer as to what is the gap. The legislation has another catch. There is a global limit as to the claim from one agent, as I understand it, and that's a $2 million limit, and a limit per claim per claimant of $500,000. Better than nothing.
Excellent. Thank you. Now, from a Western Australian perspective, Pino, you were instructed by an impacted OC who has had over 500k of misappropriated funds notified. How do you advise your OC as to the next steps to take in terms of Western Australian law and any statutory compensation claims that they could make and other avenues of potential redress?
Well, the starting point for me is to be satisfied that there is in fact a deficit, and if I'm going to be alleging fraud, that there is some independent evidence of that fraud, because professionally I can't go writing and accusing someone of having committed a fraud if I'm not satisfied professionally as to that. It's obviously a serious concern for the body corporate, because essentially their financials are now in disarray, so they should revisit their budgets. I would then recommend some urgent application be made to our State Administrative Tribunal to see whether we can have the management contract terminated, and we do have provision under our legislation for that to occur. And then obviously have a look at whether or not the existing Council of Owners, the executive, can communicate with owners not to make any further payments to the rogue strata manager, to hold their funds pending further advice as to whether or not that contract has been brought to an end, the outcome of any investigation, and appointment of a new manager. Clearly there's need for a referral to the police, because there may be some local content that might be relevant, and I would be obviously suggesting that we look to see whether or not there are any state-based assets that may be capable of being frozen as a consequence of the fraud that's taken place. But essentially, there isn't much more that can be done by the strata group, because in WA we don't have licensing of strata managers. We don't have a statutory compensation scheme. So like the other commentators, I would suggest that they obviously look to their insurance policy to see whether or not there is a fidelity cover, and obviously have a look to see whether or not there are other avenues, looking into contacting Steve in New South Wales and finding out whether we can piggyback in relation to any claim that might be capable of being lodged there. Also maybe having a look to see whether that manager happens to be a licensed real estate agent, because under our local legislation, they have to carry compulsory insurance. So you'd sort of go sideways a bit, looking for support and information. But the end result is that there is no statutory compensation scheme in WA.
Mm-hmm.
Thank you. That's very informative. And interestingly, the position in the ACT is that there is a statutory compensation fund, but only where there is a licensed agent. And in a hypothetical diddle scenario, the agent wasn't licensed in the ACT. Therefore, the applicable fund was the New South Wales Compensation Fund, or would be on a hypothetical basis. So let's move along to scenario 2. A former lawyer turned strata manager, let's call him Bill, has established himself a rather lucrative strata management business targeting smaller OCs with building defects in less affluent suburbs. The bespoke strata management agreement, accurately drafted, provides a provision that, titled delegation, to the extent necessary for the managing agent to provide services under the agreement or undertake any work for the OC and its executive committee delegates to the managing agent all of its powers, authorities and functions. This includes allowing the managing agent to take action in the case of an emergency, burst pipes, blockages, fire, failures and the like, and action with respect to fire safety, compliance and any water issues at the premises of the Owners Corporation without reference to the Owners Corporation or its executive committee. Bill, somewhat unsurprisingly, has a team of preferred engineers, lawyers and maintenance crew that Bill regularly engages on behalf of the OC pursuant to the above delegation and without any specific authority of the OC or reference to the executive committee. The OC is struggling with the cost of the reports, the recommendation of lawyers and the consultants in terms of the costs of significant works to be effected or that have been obtained without reference to the Owners Corporation or its executive committee. The committee is increasingly frustrated and concerned as to the lack of funds and current state of affairs regarding management issues. The EC is also concerned that the SM is taking kickbacks for referring the work and is charging time for project management costs. The EC has serious concerns as to how the OC's funds have been utilised and applied with no transparency. The strata manager refuses to provide financial information or to communicate other than through the owners portal and seeks to ostracise the committee from other owners. The active undermining by the strata manager is encouraged by it via other owners, lodging complaints and threats made to the EC by a single member of the OC. So panel, Jason, the chair of the EC rings you and advises that the consultant's report indicates that there is punching shear in the stairwells and that collapse of the roof is imminent if remedial action is not taken. There are no funds to cover such works, and the strata manager is proposing a loan arrangement be entered into. However, the executive committee has significant concerns as to the reliability of the claims being made and the role of the strata manager in processing such suggestions. What process can the EC undertake in relation to the strata manager?
Susan, it's interesting because the scenario started by quoting from a delegation clause in the strata manager's appointment contract, whereby that clause delegated to the strata manager all of the powers of the owners corporation and its executive committee. In Queensland, a body corporate can't delegate any of its powers. Instead, what strata managers have is that they can exercise authorised powers of executive committee members, and there's only 3 executive committee members in Queensland: chairperson, treasurer and secretary, and they don't have any unilateral decision-making power at all. So up here, first thing that I'd do is I'd encourage the body corporate to put the strata manager on notice that delegation's of no effect whatsoever, because the body corporate cannot contract out of that provision of our Act. But to address immediately the concern about the manager's conduct, the first thing that I'd encourage the body corporate to do is issue that notice under the regulation modules requiring the return of the body corporate's books, records and all of its property, so that they can independently verify and go through those records to figure out what's going on and what's happened and really see the true state of their funds. And then they should bring in their own trusted consultant really quickly, because that's concerning advice that they were given. And while they might have their suspicions about that, they need to verify it immediately, because if those concerns are correct from the engineer that the strata manager brought in, then they've got a bigger problem on their hands, frankly. So they need to get to the bottom of it. But if trust is the issue, they just need to strip the strata manager of the books, records and funds and independently verify it themselves. And the final little quip I'd add is that if the strata manager is providing project management services, that's something that needs to be licensed under the QBCC up here, so it might be something worth reporting to them.
Thank you. Tim, the EC indicates to the strata manager that they no longer have confidence in their management and that they will seek an alternative strata manager. The strata manager responds in return that the EC has not been validly constituted and therefore has no standing in making decisions on behalf of the OC. What advice do you provide to the EC in relation to the agency agreement and the potential termination of the strata manager?
Well, you probably can't give advice to not properly constituted. So you need to form a view on that. And in Victoria, it's a very difficult question. I'm still trying to work out after 23 years whether a committee is a separate legal entity or not. I understand around the rest of the country, it's fairly settled that it's not. But in Victoria, I think it is. No one else sees it that way. And there's not a single recorded judgment where a committee is either sued or been sued. But the reality is, before the Owners Corporations Act, the legislation was regulations under our Subdivision Act, and under the 89 regulations, the committee was a separate legal entity. Under 2001 regulations, it wasn't. And the intention, as far as I know, was to return to a situation where it is a separate entity. And I think that's what the legislation does, because when you look at all of the committee's activities and decision-making power go to the decision of a committee, the minutes of a committee. You're not talking about of a collective of committee members. Its references are to a committee as an entity. And then you've got the non sequitur that the duties of honesty, good faith, due care, and diligence that repose with committee members, not the committee itself, and indeed the immunity in our section 118, and most indemnity and strata insurance policies relate to individuals. So it's a real disconnect, and I scratch my head about what is a properly constituted committee. But you obviously need to make an assessment of that, because you can't advise an entity that isn't a proper entity. But clearly it's disingenuous for a manager who's been taking instructions from that collective to turn around in a self-serving time when it's going to be terminated and say they don't have the power to do that. I question whether you might run an estoppel kind of argument. The other relevant thread of the discussion. Have I still got you?
Yes, you do.
Oh, good. My screen, I've lost you on my screen, but I'll keep going, and then I'll try and work it out. Our committees are required to have a minimum of 3 and a maximum of 12 persons. And an interesting decision was made in a case known as Plan and Sec, whereby as a result of a resignation, a casual vacancy occurred and the committee existed of only 2, and the manager took instructions from it, and there was a question raised about whether the manager acted properly, and the tribunal said yes, notwithstanding that the membership numbers were less than the required threshold. The committee didn't cease to be a committee as a result of that. So it was non-compliant, but it continued to be a committee and have power. So that's an interesting one. Susan?
Yeah, no, thank you. That is interesting. John, the strata manager refuses to release information necessary, citing privacy concerns for the EC to communicate with the owners for the purposes of calling a special general meeting to address the urgent works issues. What can the EC do?
Okay, so in the New Zealand scene, like the Australian states, there's a compulsion to have a register of owners and to have those addresses updated from time to time. To access that, privacy issues do become paramount. And under our regulations, to our legislation, the chair for the body itself makes it registered any time that anyone else who decide that the body or the body need to be able to see the process conducted. We do have a useful sort of field tax in New Zealand called Curia, LIHUA, 2013 case, which examined...
Just speak a little closer to the speaker, I think.
Sorry, okay, which examined the refusal to release owner details for the purpose of circulating a memorandum to all owners. And in that case, and I'll read out the statements in the case, which are quite profound. Under the regulation 4.4, that protects the privacy interests of unit owners, extends to keeping their names and contact details from fellow owners. But the court held that interest gives way where a fellow owner wishes to contact them to generously define purposes. And those purposes include any management issues and where the use and employment of an owner is under threat. So the court at the end considered that while there was a narrow opportunity to prevent the release of information, the provisions under our own regulations are reasonably generous to allow and permit the release of material. Now, I know that anybody talks in New Zealand are reluctant to release a list of addresses to owners without full merit. And also the Privacy Commission at the moment in New Zealand is examining tenant landlord issues and proposing to a code of practice for privacy issues. That hasn't occurred in the unit title space yet, but I think we'll have to watch the space and see what the Privacy Commission comes up with in the next few months in New Zealand. So I think it's going to extend to include body corporates as well in terms of release of information.
Thanks, John. Stephen, the strata manager, dramatically resigns in a flourish at the special general meeting and thereafter notifies the executive committee that it has a 3-month period to collate the books and hand over same before it will do so. The EC wishes to access its funds and stop the strata manager from accessing those funds to continue to pay its legal fees, among other things, urgently. So what can it do?
New South Wales has a propensity to give significant delegation to strata managers, so there's a great deal of urgency in this scenario. Trust walks in the door but leads on horseback. If this is an owner's corporation that no longer has trust in this strata manager, we might now look at the tantrum at the general meeting to make a determination as to whether, on the facts, that was a termination of the contract by the strata manager or an intention to give notice. Whichever one it is, probably doesn't matter. In the event that it was a termination of the contract, then the owner's corporation will demand the return of all of its assets. A failure by this rogue to give back those assets leaves the owner's corporation in a position where it has to commence civil proceedings to recover its property. It has to start those proceedings urgently. It cannot assume an Australian bank will, for example, assist it by protecting its property on the mere production of a letter. We need urgent court intervention. In the event, however, the tantrum was a mere giving of notice, I would recommend an owner's corporation immediately terminate the agreement and continue to demand the return of its assets. And if it doesn't get those assets, to again commence civil proceedings to recover its property. I don't see a plan C.
Thank you. Pino, the EC is concerned and disenchanted about the whole process, and ultimately an administrator is appointed. What complaint mechanisms exist for the EC to ensure others do not suffer the same fate in relation to the inappropriate actions that have been taken by the strata manager?
Well, the calamity of all these facts has resulted in an administrator being appointed, which now takes control of the strata company. So the role of the executive committee, or the council of owners, as we call them here in WA, is at an end. Unfortunately, or whatever, these council of owners or executive committee seem to now want to become white knights and want to go out there and ensure that nobody else suffers the same fate that they have suffered. They need to be advised that they need to be very careful about that as to what they say and do, because there are other laws that may come home to roost. Essentially, I would be encouraging them to try and get to the administrator and try and help the administrator and encourage the administrator to investigate the rogue and do whatever they can there. And in doing all of that, they also need to be very careful about further reputational damage to their own strata complex. They've already suffered a significant blow, and Perth's a small place like anywhere else, and the word gets out very quickly that there might be issues within this particular complex. They may want to refer it to the club that most strata managers belong to and see whether or not there's a code of conduct or membership that they can invoke or lodge a complaint with to see what that's worth. Obviously, they can refer it to the government, the Attorney General or Consumer Affairs type groups and bring some other pressure to bear. But in terms of warning others and making it public, I would be discouraging them from doing more than what I've said, even though they're probably likely to be looking at the media, whether it's social media, which they're probably better at it than I will ever be, or doing other things that would bring public attention to this particular rogue manager. But the downside or the adverse consequences for them is reputational or further reputational damage to their own strata complex. So I would simply be asking them to press ahead with the administrator and making sure the administrator digs deeper and deeper and takes out whatever action that is necessary that the other members on the panel have discussed.
Thanks, Benno. Just a quick further question to that. Is the strata manager required to be registered as an agent?
No. In Western Australia, we don't. So he, the former lawyer, can open up and set up his little business wherever he likes.
Right. All right, so we're heading off to scenario 3, our last scenario, last hypothetical scenario. So the OC of Combust are precariously close to no longer being able or capable of maintaining its building insurance due to its combustible cladding casing. The broker has searched thoroughly, but the advice has come back that the Owners Corporation will not be able to get insurance until such time as sufficient remediation has occurred. This leaves the owners with significant issues, including compliance with the law, the statutory requirement to maintain insurance, their mortgage terms and potential breaches, and the threat of stigmatisation. The East, last set of questions. Last page. Sorry. Jason.
Oh.
The EC approaches you with the threat of the building no longer being insurable. What are the risks the OC faces?
Well, they're fairly obvious, aren't they? In Queensland, it's a consumer protection built into our strata legislation that a body corporate must maintain insurance cover against particular types of damage. And a lot of the damage that has to be covered go to something that's quite frequent in Queensland, and that's significant weather events. We're popular for winning state of origin, and we're popular for our cyclones. So the biggest threat to the body corporate is that they'll have to cover for themselves any damage that's caused to the building and to their common property without the benefit of any insurance cover. But it doesn't just stop at the weather events and any other forms of accidental cover. Strata insurance in Queensland has many forms of cover, and one of them is public liability or liability to others. So they're also exposed in the event of your conventional slip, trip and fall. You're not going to have an insurer step in. So owners would have to fund any compensation payout. Even up here, it's conventional to have cover against legal defences. They're going to have to pay for their own lawyers, as terrible as that might sound to a lot of people here. So, I mean, I'd pivot here, and I'd encourage the body corporate to look at ways that they can mitigate the exposure that they face. So the scenario was done on the basis that the brokers searched far and wide and couldn't find insurance cover. It's my experience in Queensland that insurers, instead of just saying no to a building altogether, whether it's the risk of cyclones or the risk of non-compliant cladding, they'll instead do exclusions, more creative exclusions to cover, or they'll put massive excesses on it. That's particularly prevalent in North Queensland, massive excesses against water damage. So I'd encourage the body corporate to speak again to the broker and see if they can go further afield to get whatever cover they could, whether that's public liability, just to mitigate the risk that they're exposed to.
Is there a statutory requirement for the OC to maintain insurance?
Yeah, there is. There is up here, but not all types of insurance. But many forms of conventional insurance has to be held. And if they can't meet that requirement, then you have to go to our commissioner to approve an alternate form of insurance. And that's embedded in our consumer protection provisions.
Is that in effect an under-insurance mechanism?
Look, what it is a matter up for debate because it hasn't been called upon that often, and the commissioner's determinations aren't publicly published. So it's almost like poking in the dark as to what you're going to get, but they have issued a practice direction. But yeah, fundamentally it is under insurance. So they've got to insure for full replacement value. So it often is getting something less than that approved as an alternate form.
Fascinating. Thank you. Tim, the EC understands there is a remediation contribution it can seek in Victoria. How does it organise itself to do this, and what is the role of the strata manager in that respect?
Well, they can register with Cladding Safety Victoria and see if they can get any money out of them. Of the 600 mil, I don't know what's left, and I don't know what's been spent on actual remediation as against other Kafkaesque bureaucratic expenses. The problem with that is that the agreements propagated by Cladding Safety Victoria are hopeless, and they're not very agile in negotiating. But the agreements will typically refer to the replacement of cladding, or what have you, on common property, and that's okay because the OC signs it, and the OC can't bind owners. But in Victoria, cladding might be wholly common property. It might be 50% common, 50% private, or it might be wholly private. And in any event, there is integration, obviously, between, or sometimes cladding might be wholly on common property, but for example, inside a balcony or something, or there might be integration at the junction where common and private meet. And so the authority is ingenuous or it simply doesn't recognise this notion of private property and how to bind that together. So we've got a problem with invoking the authority. As far as the role of the committee and the manager goes, well, it's a question of power or function. Typically, the default position in Victoria is that a committee is delegated all delegable powers. In other words, powers exercisable by an ordinary resolution. And those can then be changed, but that's the fallback position. So, assuming the committee has the usual delegated powers, the committee can do anything that the OC can do by a simple majority, and that would include invoking the authority in an effort to get some money towards the rectification. If legal proceedings are necessary, a special resolution will be required, and that's beyond the committee. As far as the manager goes, we've got a pretty clear statement in Victoria in a case called Wong, which I think was 2001, and the case concerned a claim by the Owners Corporation against the manager for contribution to damages agreed to be paid by the Owners Corporation pursuant to a settlement in a personal injury case. The plaintiff had been entering the building, had obviously been reading Alan Marshall, tried to jump the puddle, slipped, did herself a mischief. Anyway, then the Owners Corporation saw contribution from the manager on the basis that that there was a hazard. It didn't get very far. The county court probably held, I think, at least on the terms of that contract, that the manager is an agent pursuant to its contract with the Owners Corporation. It doesn't have a proactive discretionary role to identify risks and attend site with its tool belt on. Rather, the substantive decision needs to be made by the Owners Corporation, and then it might befall the manager to execute that decision on its behalf.
Thank you. John, the EC have identified and remedied the cladding issue at significant cost. Is there any compensation schemes that may be available to it? And if you can just speak in front of the microphone, that would be great.
Okay. No compensation schemes are available in New Zealand, even in the leaking home and earthquake strengthening space. The only qualified compensation you can get is through
We've just had a technical amendment, so I'll just mute myself.
Okay, so I thought I was the culprit. Usually, yeah. So look, there are class actions have been commenced in New Zealand. The global funder, Omni Bridgeway, I think they're also operating in Australia, are taking a polyurethane core case on cladding with a few buildings in Auckland. And that is alongside the Hardy Plank litigation, which rolls on for been going now for about 7 or 8 years in court in the leaking building space. So I guess we just have to wait for court actions. Government in New Zealand very reluctant to get involved with compensation schemes. We did try suing the Building Industry Authority years ago on their accreditation of products. That failed in our highest court. That was a big mistake in my view. I thought the Crown should be stepping forward with generous compensation schemes. So unfortunately, with everything else that's going on in New Zealand with earthquakes and the like, it's probably on the back burner for our country at the moment.
Thanks, John. That's great. Stephen, an OC wishes to borrow for the remediation works. How does it close out on future risk for insurability?
After the owner's corporation has notified the insurer that there is a cladding risk, it's appropriate for the insurer to then inhale from the diaphragm and get a grip. It was only on Monday of this week that the Minister for, wait for it, Innovation and Better Regulation here in New South Wales, only last Monday did they identify a preferred product for the replacement of existing cladding. Until that point, owners' corporations with fire orders and concerns about cladding did not know what product to put back after they'd pulled off the original cladding. That said, New South Wales has now moved to a position where it's got a new jazzy scheme called Project Remediate. Project Remediate is designed to give interest-free loans to owners' corporations which are qualified under the process that a group called the Cladding Task Force, this is all within the Office of Fair Trading, but the Cladding Task Force is out there auditing buildings. They've audited 185,000 buildings. To date, there are 4,127 buildings that have been inspected, and 225 of those buildings have cladding which is a threat to life safety. Now, those 225 buildings have the capacity of receiving an interest-free loan from the government to remove the existing cladding. As I speak, there are no loan agreements in existence. There is no way of knowing how those loans will be structured or to what extent there will be support. But all of that needs to be placed in front of an insurer to demonstrate that the insured is doing everything that it can to discharge its responsibilities under the policy. And it's, I think, our collective hope that that sort of disclosure would be sufficient to preserve the owner's corporation's interest. It's not the community's fault that we're in this level of chaos, is it?
No, thank you. Thank you, Stephen. And Pino, what information is the Owners Corporation obligated to or recommended to make public by way of disclosure in a sale process? Would the building be considered stigmatised?
In Western Australia, we don't have any requirement for disclosure of building defects, including non-compliant cladding. The Building Commissioner holds a register of those buildings that have had cladding issues and what state they might be in, but that's the only public register or source of information. There are two ways in which a purchaser obtains information in WA. Firstly, a purchaser can ask the strata manager or the strata company to provide information about the affairs of the strata company, and that is a certificate that's issued by the strata manager. And it references insurance policies and whether or not strata levies have been paid in relation to a particular lot, but nothing in relation to the condition of the building. The second source of information is the agent for the vendor of the particular lot. We have a requirement under our legislation that there is a pre-contractual disclosure statement, which does include information that goes to a prospective purchaser, which includes appropriate minutes, even though they might only be recent minutes, and a statement of accounts. But this is all about, and fortunately I'm involved in a hypothetical, so let's be hypothetical. This is an area as to whether or not there is a duty on agents to do more than what I've just described. Because as we know, the law of agency says that silence by an agent can be seen as misleading or deceptive. An agent, even though they have a particular principal who has a particular attitude, doesn't make their conduct any better. Their principal's thinking is irrelevant. If an agent is a professional, there's an expectation that they will give a complete answer to questions, and disclaimers and things like that just don't help. So it's a perception thing. So the question then arises as to what then is the role of the strata manager or the agent for the vendor in circumstances where they know that this particular building has significant building defects, and in particular, non-compliant cladding. And I raise that as a hypothetical because it hasn't been tested, obviously, here in Western Australia. Otherwise, I'd be quoting from cases. But it's my humble view that they could each be brought to task, relying on the law of agency and their responsibilities. So what I would be recommending to the owners corporation is that they make sure that they have good minutes of meetings, that their council of owners minutes are well documented so that there is a clear picture being painted. And hopefully a prudent purchaser, when they get a statement of accounts, will follow the money. We'll see where this strata company has been spending its money. And
thanks, Pino. I think I might need to wrap up now. I can see that the clock has run down, and sorry to cut you off there, but I hope that everyone has found this informative. I've certainly really enjoyed touching base across jurisdictions to broaden my knowledge, and I really value the fact that the college facilitates us to do this. It allows us to understand other jurisdictions and bring that back to our own jurisdictions in the context of informing policy reform and where we go into the future. So I would love to have seen everyone in person, but it's been lovely to share and to see everyone in this form as well. So thank you, till next time.